A claim can be settled at many different points in the process, and people are often surprised that a claim can be settled pre-suit, that is, before a formal lawsuit has been filed in the court. But in this blog today, I'd like to talk about the need often for filing suit, for beginning the court process. And why is that? Well, sometimes a lawyer just doesn't have enough information to make a reasonable professional judgment about whether the case can be resolved. There could be several defendants out there. There could be several people or entities responsible for the accident or injury. And in many scenarios, that is the case, that there are several. And maybe there just isn't enough information absent a lawsuit. So the lawsuit gets filed. Other times, the facts could be more straightforward, but the defendant, the person who is being sued, fails to turn a claim letter over to an insurance company. And it really requires an insurance company to have the case resolved. So a lawsuit that is begun will ordinarily, or in the vast majority of cases, elicit who the insurer is. So we have facts that sometimes require a lawsuit, and then we have the existence of insurance that isn't apparent that would require a lawsuit. And sometimes, as a matter of practice, as a matter of strategy, the lawyer can feel that the insurance company, where one is ascertained, won't take the case seriously unless the plaintiff's lawyer, the lawyer on behalf of the injured party, begins the lawsuit process. So that is yet a third reason why a lawsuit, which theoretically can be resolved before a suit, may well need to be put into suit. Now, sometimes you learn things in the course of the discovery that begins when a lawsuit is filed, and that could alert you to additional defendants. And remember, when we've spoken about the need for proximate cause, the defendant need only be responsible to, quote, a substantial contributing cause. I say only, and because a substantial contributing cause can be a lot, but the fact is there could be several defendants who were substantial contributing causal factors in an accident or an injury. And sometimes this will become apparent after the rough and tumble of what's called discovery in a lawsuit. And there are those times when you will resolve a case against one defendant, but not resolve it against one of the remaining defendants, and that can be done too. But there usually should be limiting language in a release, and a special motion has to be brought before a court under one of the rules of civil procedure to settle a case against one but not all defendants. Thank you.